Well, there's sort of two parts to this Brexit tale to where we are at the moment. There's been this long, elaborate, slightly arcane procedure, and that's dominated a lot of political debate. That's the first part. The second part is the actual outcome of it. What has happened as a result of that, the sort of the legal regime that we'll be left with if the United Kingdom leaves the European Union. You've had this sort of almost trench warfare between the two sides, where procedure has been used fairly aggressively by each. And so the arcane procedural points of sort of what does Article 50 require, what constitutional requirements did it put on the United Kingdom, debates of the relationship between the Parliament and the government, and between Parliament and courts, have really been prominent in the stage of Brexit. And it's worth just talking a little bit about that. There was, first of all, the UK government made a decision, and it probably had no choice, that it had to follow the treaty in leaving the EU, and so you had this debate about what Article 50 meant. And that obviously generated its own issues, because it was then discovered that it required an Act of Parliament to formally notify that it was leaving the European Union. That was the first challenge. Secondly, as we've gone along, we've then had the challenge of, if you like, the government being able to leave the European Union without a deal in place for withdrawal, and what would that mean? And then further parliamentary procedural constraints were put in place, that Parliament could adopt a motion, which it did, requiring the government to seek an extension, which it did. So there was then the issue of whether the government could prorogue Parliament to stop it debating Brexit, which the UK Supreme Court said it couldn't. Now, if you looked at a lot of these issues, they are very interesting constitutionally. They tell us a lot about the UK constitutional settlement, and no doubt, I think constitutional lawyers in particular will spend a lot of time analysing them in the future. Brexit has done quite a lot to the UK constitution. It has forced the UK Supreme Court to say something about its powers, and also the power of the Parliament vis-à-vis the executive. There's more broadly the question about to what extent the government can control the agenda in Parliament, and to what extent it can't. And that's very interesting. I do think it is something which we'll be most focused on in constitutional and administrative law courses, and perhaps over time will be seen as less central to debates in EU law courses, albeit that I might be wrong about that. Now, if you look at the second stage of what's happened, which is, well, what's the law after Brexit? We're really just at the beginning of that process, because there are three parts to it. The first part was what was adopted in 2018, which was the EU Withdrawal Act, that even if the UK left without a deal, or left without any free trade arrangement or anything like that, the fact is that EU law is going to matter in the UK for a considerable time, because the EU Withdrawal Act says that basically all the EU law in place before the UK leaves on the 31st of January 2020, all the EU law in place prior to that date takes precedence over any UK law that was adopted prior to that debate. And that matters just because there's so much EU law, the so-called retained EU law. Courts are going to be having a regard to EU law, in my view, for the foreseeable future. So that's the first thing. Now, the second part of this process is the part that prompted the current election. The legislation, a bill was put forward for the EU Withdrawal Act to get that through. This was a new agreement negotiated by Boris Johnson. There were amendments to the protocol on Ireland, Northern Ireland, which provide for some checks really between Great Britain and Northern Ireland as a way of ensuring that there's no visible frontier between Ireland and Northern Ireland. And that is currently stuck, whether that bill will be adopted or not. Now, assuming that bill is in due course adopted and becomes an act in early 2020, the third piece of legislation that will have to be put in place in due course is that legislation which would implement any free trade agreement that is made between the United Kingdom and the EU. And we'll have to wait and see what is the content of that and whether it takes place. But at the moment, the Boris Johnson government is committed to negotiating a free trade arrangement between the UK and the EU by the end of 2020. That arrangement, it looks like it would provide, if it's agreed, for significant free movement of goods. There would be no, the aspiration is no tariffs on trade in goods between the UK and the EU, and hopefully few non-tariff barriers, regulatory barriers to trade. It's likely that it will be difficult to have the same regime in services, that there will be significant restraints on free movement of services, and certainly there's no ambition to have a liberal regime to have free movement of persons. There is still the question of the so-called level playing field requirements. The EU has said that it will insist on so-called level playing field requirements. These are laws which go to whether a state seeks to get a competitive advantage by deregulating its taxes, its labour laws or its environmental laws. And it says, depending on the level of economic integration between the UK and the EU, it would seek to secure certain guarantees there, that the UK won't be able to engage in a race to the bottom if it wanted to. Now, the Boris Johnson government has said that it's not really committed to doing too much there. But if they do manage to get agreement, and that is a big if, one would expect that these have to be put in place in any UK legislation. Certain guarantees, certain minimum guarantees about certain environmental laws and labour laws, and possibly certain guarantees on corporate taxation, as this can also be seen as a way of getting unfair advantage and getting companies to invest in your territory at the expense of other jurisdictions. So we'll have to see where we go with that. At the moment, we're sort of a third of the way through that football match. We've agreed, if you like, as a first third, that all existing EU law will take precedence over all existing UK law, and EU law will be there until any EU law until it's expressly repealed, and that includes judgments of the Court of Justice until they're expressly repealed by the UK Parliament, which will keep the UK Parliament very busy. We've got a plan in place for the second stage, which is the withdrawal agreement, which will set out relations between Northern Ireland and Great Britain, the rights of the EU citizens in particular, here in the UK. And that's just a plan in place. It still has to be adopted as legislation. And then there's this third, rather inchoate view. There's a political declaration, but it's still quite vague in my view, about what future sort of trade security relationship will be between the UK and the EU. And that will need legislation in place. And we'll just have to wait and see how that all goes. But it does mean that it will be keeping EU lawyers a little bit busy for the foreseeable future.